All right. Good afternoon, everybody. It's 12 o'clock at the end of the month, last Thursday, and you're here with us at the Haynsworth Sinkler Board Employment Law Webinar. I'm Joseph Dickey. It's my colleague, Katie Busbee, and we're here to do a mid-year employment law update. It has been an exciting, I guess one of the words to call it, year for employment law. Things have been changing ever since, I guess, what was it, January 20th or whatever the inauguration was. It's been changing, and right now the world's changing. So we got some things to talk about. Some of these things probably have been beat to death, but it is important to kind of go back through some of them, which Katie and I are going to hope to do today. So you could have been at lunch, you could have been out on a nice day, but you're here with us, and we're going to try to make that mildly enjoyable for you. Before we jump into it, we always got to, as I would like to call it, pay some bills, like do commercials. We are if we go back real quick, five office firm across 2 states with 115 plus attorneys, full service corporate firm. We can help you or anybody you know in any way, please give us a call. We would love to be of assistance if we can. As always, if you have questions during the webinar, please just ask them. We want this to be informal. We want this to be fun. There is no filter, so ask your questions however you want. We want it to be as interactive as possible. Would love to see everybody and be able to talk to you, walk to you, but this is how we got to do it. So just pop your question in. We'll try to address it. All right, let's go. So back in January, I think it was Katie and I, we were given things to expect under the new administration. And one of the things we talked about was agency rulemaking after Loper Bright. If you remember the Loper Bright case, overturned longstanding Chevron deference, where the courts were required to defer to agencies on ambiguous statutes. And so when you look at that, I'm not going to get into the technical legalese, but EEOC would implement guidance, or there would be regulations implemented from an agency, and the courts would be required to kind of look at that. I know we've all probably come across cases, employment cases, where we've had discrimination cases where the court has kind of cited to rules the EEOC or another agency has implemented, and that was part of the Chevron deference that was longstanding. Now, however, that has changed. The Supreme Court, which has been active in employment here in the past year and a half, 18 months, and still active, which we'll get into a little later, said that they criticized Chevron for conflicting with the Administrative Procedures Act and believed that the courts needed to exercise their independent judgment in deciding whether an agency has acted within its statutory authority. So that has had just some widespread effects on employment law. And it's been just a start of some other changes where you're looking at the courts and the landscape changing from giving agencies independent authority, giving deference to what has been or what has been longstanding perceived rules, to a changing of the guard, so to speak, or a change in a thought process change. And this leads into a changing of where protections may lie, whether that's under Title VII, which that's going to be a lot of our talk today, whether that's under the ADA, disabilities, or any other protected class. And so if you go to the next slide, specifically, we talked about implications, but of here, who knew when we talked about this in January that we said that the Pregnant Workers Fairness Act could be impacted by these changes, and that's exactly what happened with a case that got ruled by in the Eighth Circuit. The Eighth Circuit Court of Appeals ruled on a case back on May 21st, 2025, where it impacted the Pregnant Workers Fairness Act and struck down the abortion accommodation. Which was fairly interesting, but that's just keeping with the new administration's tenor of striking down longstanding rules and making sure things are going back to more independent judgment, whether that be with the courts or whether that's with the states, which is what happened with the abortion accommodation, which hopefully we'll have some time to talk about later on today. And if not, we'll kind of send a little something out with our presentation afterwards. But that's kind of what we're going to get into. So you take that framework and we go into the harassment guides, which also we've talked about. But we're doing all this to lead you into where we're going. So you had those things happen with the local bright. We're going to start looking at independent judgment. We're going to start looking at, well, maybe these protections are extending too far. Maybe we're going to we need to make sure we're protecting all people. So the EEOC issued harassment guidance and kind of made things a little broad back in April of 24. And, we talked about it back in September of 24. Well, obviously things changed. And there's now been more of a, I guess, Katie, I don't know what you would call it, a subjective kind of view for a hostile work environment. Previously, if you looked at guidance, objective hostile work environment, is if objectively reasonable person thinks things were severe and pervasive in their workplace, and we thought it was unwelcome, yeah, that could qualify as a hostile work environment. But now, with the changes that have come, that says it's subjective. Did the actual person in the situation think that? And that changes things when you're looking at hostile work environment, whether there's unwelcome harassment. You know, you have cases. I know some of y'all have maybe had cases where people are making claims. Well, employee, John did X to me, or employee Katie did something to me. But as HR or as another supervisor, that they have this friendly relationship, and there might be some kind of just a disagreement right now. Well, the court now can take that into consideration and look at that as, all right, subjectively within that situation, is that unwelcome harassment. What's important about that, but that's more of a procedural thing, is that the guidance can't be modified without a majority vote of the commission. As you probably know, there's some flux in the commission right now. Don't know if we have a quorum, I can't remember, but that's all that's about. So we keep going. I think we talked about the definition of harassment, but in case we didn't, it's harassing conduct is usually unwelcome. It is not permissible. It's usually just pertaining to protected classes. So I know you get people that say, I'm in a hostile work environment, and they might be a 30-year-old white man who's getting harassed by another 30-year-old white man, and both are straight. It's not really a hostile work environment under federal law. Maybe the other guy just doesn't like you. But people like to use the hostile work environment to, as a key trigger word to get y'all to call the lawyers, to get you to start panicking, to get what they want. We've all been there. So I guess it's good to just have it up there and say harassing conduct is covered if it pertains to a protected class. Unfortunately, at least I guess for a certain group, excuse me, people, with some of the changes in the guidance, some of the changes in the agency rulemaking, if you go to the next slide, the EEOC is taking position, as stated by President Trump back in January, and we can go next slide, that they are not going to be prosecuting or moving forward with any transgender cases, transgender discrimination cases, or gender identity cases. This I think is what Katie was, this Bostock case back in 2020, with that held that transgender gender identity was covered under the EEOC Title VII. That while the law has not changed, the president has issued an executive order that we have two sexes in America, and the EEOC, OFCCP, because if you still believe it exists based on the budget, they are not to move forward with these cases. So if you have these cases, or you've been dealing with them, whether you're a lawyer or employer, these cases have been kind of just sidelined. Nothing's happening with them. And so, but for guidance purposes, if you have a transgender employee, gender identity employee, since the law hasn't changed, we would still, recommend to you to, go through your processes. If there's a reporting or complaint process, you need to still, address that in the appropriate way. Take the complaint, do an investigation, take action if need be, keep things confidential. Title VII hasn't changed. EEOC is not prosecuting the cases, but where there's a will, there's a way. There's no need to have bad evidence and go down a path that probably is going to get you in trouble just because there has been some, I guess, philosophical changes or edicts that have been prescribed without any change in the law. But it's something that you definitely know. And so
Yeah,
again,
so I'll just jump in and say, yeah, it's just important to remember that that EEOC guidance has not been rescinded at this point. Even though there's been some statements by the EEOC, like Joseph was saying, change in how they're going to go about things. And I actually just saw today, a New York judge resigned, or I guess was terminated. She was put on leave because she was kind of refusing to comply with halting these transgender cases. Uh,
yep,
yeah, so the EEOC is certainly turning a page on this, but that harassment guidance has not been rescinded. So yes, follow through with your normal investigation process.
right. Thanks, Katie. And so again, we've had rollback in agency on deference. We've had rollback in, what we are considering in as discriminatory or protected class in kind of Title VII EEOC, at least in, statements or otherwise. And now that takes us to DEI, which we've been talking about DEI for a while. And you are continuing to see rollbacks with DEI, and you're continuing to see opposition in DEI. There's been the executive orders that came through from the White House have said that the illegal DEI is covered under Title VII. It is something that whether you're a state agency, federal agency, you cannot engage in. But it's very carte blanche to say you can't do anything DEI related. But that isn't while that has what's been said, that's not necessarily what is the, I guess, the real life implementation or how it's applicable under the law. So let's go back. What is DEI? It's not defined in Title VII, but DEI is usually initiatives that try to make an equal playing field. It's not affirmative action where we're saying we're going to, out of 10 people, hire two Black people or two minorities or people out of protected class based on their protected class or their minority status. It's just trying to make an equal playing field. So sometimes the terms are being conflated, confused, however you want to say. But now the climate is that DEI, in at least how it's been stated in its forms, is illegal under Title VII. So how does that look in reality? Initiatives, programs where employers are, I guess, separating employees based on protected classes, whether that be religion, whether that be race, ethnicity, or otherwise, could be considered in violation of Title VII. If you are a recipient of federal contractor or another recipient of federal funds, your funds could be withheld from you based on the new executive orders, based on how the president is, advocate for the law to be implemented. If we go to the next slide, the acting chair and Andrea Lucas has said, and I'll read it about DEI and how it applies with Title VII. Far too many employers defend certain types of race or sex preferences as good, provided they are motivated by business interests in diversity, equity, or inclusion. But no matter the employer's motive, there is no good or even acceptable race or sex discrimination. So this is again, we have this gradual train that we've got. We're rolling back agency deference. We're kind of rolling back, what's that's covered under Title VII. We're kind of rolling back, initiatives for DEI, looking at trying to level playing field, and we're going to say, all right, everybody's on one accord. These initiatives that needs to be taken out. There doesn't need to be any extra protection. We're going to roll that back, and we're just going to take things at face value and let independent judgment occur for whether there's been discrimination, harassment, retaliation, and that's going to be done at the state level. It's going to be done case by case based on in the courts. And that's going to be done regardless of whether you're in protected class, minority group, or you're part of a majority group. And this is kind of what Justice Thomas said in a concurrence for the fair admissions case. Two discriminatory wrongs cannot make a right, which is akin to his position when affirmative action was coming through some years ago. So we go to next slide. The EEOC and DOJ has issued technical assistance documents, which we've kind of explained in prior on webinars. It tries to educate the public what's unlawful discrimination. It gives you do's and don'ts, but there are other ways to kind of look at this. And there's actually been a case because the law has been on the books, but now we're having, I guess, I don't want to call it a renaissance, but I'll say we're having just this, again, this change of philosophy or change of thought that is actually having it said out loud in more cases, Supreme Court and otherwise, and not just by circuits. But the laws have been on the books since before January 2025, and the best way to kind of demonstrate that there's what not to do for illegal DEI is to look at a Novant health case that occurred in North Carolina. And then we've talked about this previously, but I want to go into it in a little more detail today because it's going to lead into kind of the most recent ruling from the Supreme Court in Ames, where we had a, what was it? Is this a religious case or?
It's a gender identity.
Yeah, gender identity case. Because we're not just talking race, we're talking any majority group. And so you go through the next couple of slides, we're just giving you examples of what, based on the technical assistance documents and guidance, that DEI programs are prohibited under Title VII if they prefer one group over another, of employees over another. They try to exclude employment opportunities and benefits on the basis of protected status, or they do training that is based on protective status. All of this can meet the definition of either illegal harassment, illegal discrimination, disparate treatment. Next slide. Certain groups, I guess I've heard things and seen things like celebrating Juneteenth, where you're not celebrating another holiday, could be illegal DEI. Certainly using, having, I guess, let's say we have a Muslim Administrator's Day. If that's something that's celebrated at work, that could be illegal DEI. If there are affinity groups, that could be illegal DEI. You could say we're going to have a minority scholarship. A lot of law firms got hit with that, minority scholarships or clerkships. That's had to change. Even with colleges, some I know Clemson has gotten hit with certain things, whether it be a minority programs such as what Clemson used to have, Math Excellent Workshop, Career Workshop. That used to be minority exclusive workshop, minority inclusive programs now are opened up, and that applies to endowments as well. All of these things can be considered illegal DEI. So let's go to Duval versus Novant Health, which was in North Carolina. You go next slide. Let's go to the Duval slide. And yes, this reverse discrimination case. It was brought against Novant Health. It was brought in, I think, 2018-19 by a white male executive. And he got litigation, went to litigation, got jury verdict, $10 million of punitive damages and over $3 million back and front pay. Court stated in order addressing post-trial motion, a reasonable juror could infer that the company was aware of federal anti-discrimination laws, understood the stated goals of its DEI program, and was willing to terminate a white male in order to advance diverse candidates and promote the company's stated goals. Now, this was before January 2025, obviously, but that is the philosophy. Whether white, whether you're physically able, disabled, Muslim, Christian, Seventh-day Adventist, gay, straight, heterosexual, whatever the case may be, Title VII applies to you, and you can be discriminated against. And so let's look at next slide, the facts, so we can get into really looking at how this becomes illegal DEI, how that applies now. Duval was a white male who was SVP, a senior vice president of marketing in Avant since 2013. He had an African-American black male supervisor as his chief consumer officer. Duval was documented as a great employee, great performance, and he also was a member of the subsequently implemented D&I Council, Diversity and Inclusion Council. Duval, however, was terminated in 2018 unexpectedly by his supervisor. Still had no performance issues or anything. Almost immediately after Duval was terminated, Novant promoted two deputies that worked under Duval, a white woman and a black woman. I believe one of the women had deficient performance reviews in her file. Then later they hired yet another black woman to permanently replace Duval. So that's 3 women that were added to replace Duval. Next slide. In 2015, this is 2 years after Duval's hiring, Novant issued a strategic plan, a D&I strategic plan that they wanted to implement. Phase 1, learn and engage. This would assess Novant's diversity and inclusive culture, benchmark its diversity and inclusion levels, and seek to get the board's leadership and commitment to using D&I in decision making. That's important to know. They want benchmarks. They want to use D&I in decision making. Phase 2, develop and influence. Set goals to embed diversity and inclusion in 3 to 5 years. Commitment to adding diversity to executive and senior leadership teams. So again, setting goals. Want to add diversity to the leadership team within 3 to 5 years. Phase 3, leverage. Is where they want to evaluate their progress. This was approved in November 2016. We can go to the next slide. 2 years later, or almost 2 years later, May 2018, the D&I Council, which Duval was a member of, evaluated the demographic data that Novant had collected since the time. They determined that the data showed a decline in female leaders and a reduction in African-American representation in the company at each level of management as you went up. So again, you looked at the phases. We're looking at goals, benchmarks, how we want to look. And we're looking at data to make decisions. And so after the council that Duval was a member of, shortly after, guess who got terminated? Duval. And when he was terminated, he was given no reason other than they're going in a different direction. Well, that different direction Duval knew of. It was a direction of D&I. And I guess when October, 4 to 5 months later, or even shorter than that, during the minutes of a D&I council meeting, the council that Duval formerly was a member of, Novant Health said the following, and this was recorded. We, Novant Health, are not interested in meeting quotas. Quotas are mandated by someone outside of your organization. We want to reach our targets. Targets are set by the organization, which is within our strategic imperatives, and making sure our workforce reflects the community we serve. So there's an attempt to make to distinguish between quotas and targets based on their strategy. I see no difference, but they try to make that difference. And so what happens is we go forward to the next slide, and the court looks at, whether the evidence presented by Duval showed that he was discriminated against. Yeah, yes. Novant Health implemented a full D&I plan that largely just looked at numbers, demographics, and how things look, data and how things look. Decisions were made to terminate Duval, and quite frankly, after Duval, they terminated other white men in leadership positions just so they could add people and make a collection of executives that look diverse. Nothing was based on performance, evaluations, or anything. It was just making sure they hit their quantitative goals, their targets. And the court said, and the Fourth Circuit upheld that that's discriminatory. That was a D&I plan that is discriminatory. And, it just looked at the adverse action, the usual suspects, a shifting basis for its termination. But more importantly, the last bullet, I have the quantitative data and metrics. And so that's illegal DEI. Now, is DEI illegal for you to do it at your place of work, at your establishment? No. But again, we've said it before, you need to evaluate. You need to have a confidential audit or DNI program or DEI program, and make sure that you're not conducting yourself as in Novant Health, because the landscape is changing. And while that would happen isolated kind of in North Carolina and went up to the Fourth Circuit, this is the prevailing view where we're not even looking at quantitative issues. We're looking at how we're evaluating on a case by case basis the actual facts, and without looking at heightened circumstances or heightened scrutiny of everybody, whether you're a majority or minority group, of whether you're being discriminated against by your employer based on any characteristic. And that leads you into the Ames case that was decided, what, maybe 2 months ago, Katie?
Just a few weeks ago,
2
actually.
weeks ago. And
Yeah.
Katie, talk more about that, because this is where we are now, and that's how we crescendoed up. So sorry for taking a long time, and Katie, you jump into that.
All good, yeah. So we got a decision a few weeks ago from the Supreme Court on a reverse discrimination case, and of course, Novant that Joseph just covered was also a reverse discrimination case, looking at it a little bit from a different angle. But I think we probably should do a little quick review on Title VII. What is Title VII? I'm sure many of you out there know what it is, but if we have anyone new, so Title VII of the Civil Rights Act of 1964 prohibits discrimination based on certain protected classes. It applies to private employers with 15 or more employees. And I have the actual code section here of the discrimination statute, because this came up in the Ames case and it also came up in another case we're going to talk about. But this is the plain language of that statute that says it shall be unlawful and unlawful employment practice for an employer to fail or refuse to hire or to discharge or to discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of such individuals' race, color, religion, sex, or national origin. So again, that is the plain language. There's no mention of a different standard between majority or minority group plaintiffs. A very general prohibition based on certain protected classes. And this has really been expanded to by case law as well. You go to the next slide. So, I mean, the Bostic case, and there have been other pregnancy related cases too that have expanded what does sex mean under Title VII. So, that's now been held to include pregnancy, sexual orientation, and gender identity are under that sex umbrella under Title VII. And so, discrimination, just from a very high level, is unfavorable treatment based on one of those protected classes. And so when we talk about this concept of reverse discrimination, this is really a term that courts started using to describe a situation where you have a member of a majority group. So usually this is coming up in situations like Novant of a male, a white male, or a white employee, or a straight employee or something like that, a member that's a part of a majority class, right? And they are bringing a Title VII claim, also arguing that they have been discriminated against based still on their race, sex, things like that, but they're a member of a majority class. And so over the years, this is not a new concept, but it is an area, like Joseph said, that is changing. And the EEOC and courts have really taken different approaches over the years on how to deal with reverse discrimination. Next slide. So the EEOC has made several statements on this over the years. Excuse me. So they put out guidance years ago on race and color discrimination and hit on this idea of reverse discrimination. And they basically said Title VII prohibits race discrimination against all persons, including Caucasians. Some courts, however, have taken the position that if a white person relies on circumstantial evidence to establish a reverse discrimination claim, he or she must meet a heightened standard of proof. The Commission, or the EEOC, in contrast, applies the same standard of proof to all race discrimination claims, regardless of the victim's race or the type of evidence used. So again, some courts have started to apply a heightened standard that only applies to people in a majority class bringing a discrimination claim. And so the EEO is saying, we don't impose a heightened standard. And so this is also the reason too that we're covering this is that the EEOC mentioned this as well in the new DEI guidance that it put out. And they just really reiterated their stance on this and said Title VII's protections apply equally to all workers. The EEOC does not require a higher showing of proof for so-called reverse discrimination claims. The EEOC's position is that there is no such thing as reverse discrimination. There is only discrimination. So the EEOC has actually been pretty consistent in this, but where we have gotten diverging opinions is really in different courts. Next slide. So I think it's important to talk a little bit about, when we have to work on a Title VII case, so when we're helping you all with an EEOC claim or defending a Title VII case, typically we are dealing with a situation where there is indirect evidence of discrimination, right? I'm not usually dealing with a case where someone is being told, you're being terminated, because you're a woman or because you're Black or whatever, that is rare. Usually it is situations where we have circumstantial evidence, where that plaintiff has circumstantial evidence. So the McDonnell-Douglas framework is the framework that courts evaluate these types of cases. And so for a typical plaintiff bringing a Title VII discrimination case, they have to meet what's called a prima facie showing. So there are certain elements that they have to meet to even be able to bring a Title VII claim. And it's actually typically pretty easy to meet this burden at the initial step. And so they've got to show that they are a member of a protected class, that they are qualified for the job or performing the job satisfactorily, that an adverse employment action was taken against them, and that there's some kind of causal connection between their protected class and that adverse employment action. And that's usually a situation where they can show an employee outside of their protected class was treated more favorably, right? So a situation where I didn't get hired, I'm maybe a lesbian employee, I didn't get hired. Look at this heterosexual employee that did get hired in my place. So they're able to point to someone outside of their protected class. So Title VII plaintiffs have to meet those initial elements. And once they do, the burden of production then shifts to the employer. And the employer has to be able to give a legitimate, non-discriminatory reason for the employment action that they took. And again, this is why when you all are calling us, when we're talking about terminating an employee, we're asking them, one, why are you terminating them? Usually you're telling us it's performance related, misconduct, all these things. And then we're asking you, well, what do we have in writing? Has that been communicated to them? Do we have a file showing that this legitimate non-discriminatory reason? Because we know that burden of production is going to pretty easily shift to the employer. And so once the employer puts forth that reason, the burden then shifts back to the plaintiff. And the plaintiff has to show that the proffered reason is a mere pretext for discrimination. And that is a higher showing. That's usually where plaintiffs have a harder time, right? Like they can usually make out a prima facie case, but the pretext is harder to show. And that burden of proof always remains with that plaintiff, even though the production is shifting back and forth. So that's a typical Title VII case. And what has happened in these reverse discrimination cases is that courts have not been following this. They've actually been imposing a heightened standard for plaintiffs to make that prima facie case, that first step. And so the 6th, 7th, 8th, 10th, and the DC circuits had all adopted this test called the background circumstances test, where they've basically said, if you're a member of a majority group, so, you're white, you're male, you're straight, there's others, but those are the ones that typically come up. You're going to have to prove you're going to have heightened evidence, right? We're going to make it a little bit harder for you to establish that prima facie case. because you're going to have to show that your employer is unusual in the sense that they are actually discriminating against a majority. So some circuit courts had adopted this heightened standard. The Fourth Circuit, they actually they had repeatedly declined to take a firm stance on this, and it has resulted in district courts doing different things. Like there's cases in the Fourth Circuit where some apply this background circumstances test in certain district courts and others that do not. So it's just caused varying standards, right? But now the Supreme Court has weighed in, and that's the case that we're going to get to next. And so just a few weeks ago, Supreme Court came out, Ames versus Ohio Department of Youth Services, and basically to address this issue of this heightened standard that courts have been putting on majority plaintiffs. And so the facts of this case is that we had Marlene Ames, who is the plaintiff, who identifies as a straight woman. She began working for the Ohio Department of Youth Services in 2004. She was promoted in 2014 to a program administrator. And in 2017, she got a new supervisor who identifies as a gay woman. She then got a new program director, so kind of 2 steps above her, who was appointed in 2019, and he is a straight man. Next slide. A new position was created and she applied for that position. It would have been a promotion. She was passed over. She did not get that. And instead a gay woman was hired. And then right after that, in May 2019, she was actually demoted back to her original position. And then later that month, her position was filled by a gay man. Next slide. So you can probably tell where this is going. She brought suit alleging discrimination on the basis of her sexual orientation. I think I said gender identity earlier, sexual orientation, based on failure to promote and the fact that she had a demotion. Because she's a heterosexual, she is in a majority group, right? And she brought suit in the Sixth Circuit. And the Sixth Circuit has this higher standard. They've adopted this background circumstances test, this higher standard, where she would have to show that her employer is unusual in the sense that they are actually discriminating against a majority group plaintiff. The district court dismissed the case and basically said that she did not meet this heightened standard. And the Sixth Circuit affirmed that. And in their decision, they actually talked about how, if the normal prima facie standard was applied to her, she would have met that, but she's not been able to meet this heightened standard. And so she appealed to the Supreme Court and the Supreme Court granted cert. And so the Supreme Court looked at this and they basically looked at the plain text of Title VII, that statute I had up earlier, and they held that this background circumstances rule that's been applied by the Sixth Circuit and other circuits, where they are requiring a majority group plaintiff to meet a heightened standard, is not consistent with the text of Title VII. And so they basically have invalidated that heightened standard, and they sent the case back down to the district court. And they really looked, again, just at the plain text. They said, listen, the discrimination statute under Title VII does not make distinctions between majority and minority group plaintiffs. And all of our precedents has been to faithfully apply the plain text of Title VII. And so, they have really stepped in and said these heightened standards are not going to be required anymore for majority group plaintiffs. And so again, we're just furthering, we are continuing to shift, like Joseph was saying, I think with these decisions. And this came out a few weeks ago. We also had a case that came out last year, but I think it's also important to talk about that one. This was a situation where, in Ames, I think we are going to see potentially more reverse discrimination claims. We also had a case last year that came out from the Supreme Court that I think is also going to make it a little easier for people to bring Title VII claims. So This is Muldrow versus City of St. Louis. In this case, we had a plaintiff, Sergeant Mulbrough, who had worked for the city from 2008 to 2017 as a plainclothes officer. In 2017, her director actually asked to transfer her to a different unit to replace her with a male officer. She did not want to be transferred, but the department approved the transfer and she got moved. Her rank and pay did not change. I do feel like this comes up a lot in conversations I have with employers when they're wanting to reassign or transfer an employee. In this case, she's getting paid the same. Her rank is not changing. But she has now been reassigned to a different position. So her responsibilities did change. She lost a perk, and then her schedule also changed. So, she was no longer working with high-ranking officials on department priorities, and instead she was supervising the day-to-day activities of patrol officers. So, in her mind, her argument certainly was she was performing lesser work in this role. She was no longer able to drive unmarked vehicles. And she went from having a set schedule to having a flexible schedule, and she had to work some weekends. So she ended up bringing a claim under Title VII for discrimination based on her sex. And, the issue here was essentially in making out her prima facie case, did she actually suffer an adverse employment action? She wasn't terminated. She wasn't formally demoted, right? Like her title, her rank, and her pay stayed the same, but she was reassigned. And so the district court dismissed it, granted summary judgment for the city. And the district court and the Eighth Circuit kind of applied this heightened standard, saying to show you had an adverse employment action taken against you, you have to show that you suffered a material significant disadvantage. And they basically said that she did not meet that requirement. And so the Supreme Court granted cert. And they held that, like, hey, that is actually too high of a standard. Again, we're going to lower that standard. All she has to do is show some harm, that this reassignment harmed her in some way. She doesn't have to show that it significantly harmed her. And again, they looked at the plain text of Title VII and they said, Title VII says employers cannot discriminate against an employee in a term or condition of employment based on a protected status. And so this language, discriminate against, just means to treat worse. Again, like unfavorable treatment. It doesn't impose this higher standard that has to be significant.
And Kay, if I can interject, I see this a lot. The first thing that comes to my mind is school districts or colleges or things. You have, because you already have prescribed requirements regarding, whether it's be tenure, teacher contracts, and, the ability to assign people where you want to place them for the betterment of either the district or the college or, another entity. And the defense always is, and we've done this for decades. It's you have the same pay, you have the same position. Now that might not be the case. I've seen situations where it has been perfectly lawful to take, let's say, an administrator or assistant superintendent or a lead teacher and reassign them to a coordinator or some other role under the same pay and seniority, but they're in a smaller office. They're not in a leadership position anymore. They're kind of just doing run-of-the-mill work. And there's actually nothing you can do as far as if you're a plaintiff or represent that person to kind of challenge that. Now you can, based on Muldrow. How that will play out in a court, who knows? But there are now with these decisions, there are now there's probably going to be an influx, an increase in claims, whether it be quote unquote the reverse discrimination, or there's going to be claims that you wouldn't normally see being brought and that attorneys would normally turn down. And so it's interesting. And it's also interesting to note, I don't know how closely everyone is following it, but Justice Ketanji Jackson was joined in both these opinions and actually authored the Ames opinion. I think that's interesting. Based on the political leanings of the Supreme Court. So if Justice Jackson is the one authoring the Ames opinion, I mean, we're clearly in having a new landscape of how we're looking at Title VII discrimination claims, and that's going to go forward for at least a generation. Because who knows what's going to happen with appointments on the court? But if Justice Jackson is authoring the opinion, we're in a new world. We got a new playing field.
Yeah. Yeah, and Justice Jackson being an African American female too, right? Yeah. So that's kind of the point that we're making there. And so yeah, and I get calls from, Joseph works a lot with public employers. I get calls from private employers that also want to talk about this all the time. Like, hey, can't we move this person? We're not changing their pay. We're not changing their title. It's not a demotion. We're just giving them a different position. And, I think this case really does illustrate, well, I mean, you can, but there's some risk there, right? Like if they're performing lesser work, they in their mind, they know they're getting demoted. It doesn't necessarily matter that you're not changing their title and their pay. They feel like it's a demotion because they're doing lesser work. And so that's a good example of this.
And you can see that, when you're looking at trying to bring a worker back, let's say from FMLA or a USERA claim, or you got a workers' comp issue, and that employer might not have been the best person at that job, but we don't have the documentation. So you just kind of put them in a role just to keep the spot. In the past, that would have been, well, at least we're compliant with the law. Maybe they'll quit, or, things will work out. Well, now they might have a claim. And so things will have to be very strategic, thought out, planned for how we accommodate individuals who are returning, how we preserve or administer job protection under certain statutes that require it. Because we can't just bring somebody back and keep paying them. We have to actually be mindful in how we, implement that or reintegrate that person back into the workforce. And I think that's going to cause some claims additional claims to get made. There's going to be an adjustment period. We might have more settlements. You might hear us recommending to probably dispose of a issue more than litigate, just so we can get through it, because the landscape's changed. The rules have changed in the middle of the game, and now we have to adjust, and that's always hard. But that's why we're doing the update.
Okay, next slide. So again, I just think this could result in more reverse discrimination claims. I think it, like Joseph was saying, it could maybe change our analysis a little bit on when you are trying to bring people back or reassign them to a different position. So just be aware of that.
All right. So again, we're still talking about Title VII. That's kind of what we're talking about. That's been the main thing this year. I know we don't have long left, but I do want to talk about the state of Louisiana versus the EEOC case. This is a case that was just decided on the 20th, I believe, of this year. And oh no, it was May 21st. I said, and I mentioned it earlier. And this concerns the PWFA, Pregnancy Worker Fairness Act. As we know, the PWFA was implemented during the Biden administration, I believe, and it requires employers to make reasonable accommodations to the known limitations related to pregnancy, childbirth, or related medical conditions of a qualified employee, unless there's an undue hardship. Now, this extends kind of a more extension, that's how I look at it, at least, an extension of the Pregnancy Discrimination Act, the PDA, which is already under Title VII. But this is more specific and kind of provides some more protections for those workers. The PWFA describes or defines a known limitation as a, let's just say, physical or mental condition related to or affected by or arising out of pregnancy, childbirth, or related conditions. The PWFA, much like FMLA, applies to government employers who are covered, 15 or more employees. Next slide. And so in August 23, the EEOC proposed a rule regarding the PWFA that would include state employers that would accommodate elective abortions. Now, abortion has been the topic of the week for years now. It still is. I think we have an issue going on now where we had a sitting U.S. rep who had a unfortunate ectopic pregnancy who couldn't get an abortion here recently, which would have been simply a medical procedure to help her with her unfortunate pregnancy, but she couldn't get it. So I hope she's doing well, but that's kind of where we are. But I think that is considered maybe an elective abortion at this point, or it won't be considered something that you can do after 6 or 8 weeks, depending on the stage you're living in. And so in 23, just to go back, in August 23, the rule was proposed not to accommodate those type of elective abortions or just a elective abortion in general. April 19, 24, EEOC had contested language that they want to insert into the final rule. Basically, when having an abortion, um, I don't know what I've heard. Having an abortion is an example of a pregnancy, childbirth, or related medical condition that employers are therefore required to provide employees with a reasonable accommodation for under the PWFA. This was inserted into the final rule. It made abortion accommodation part of the law. Employers had to do it. Well, the state of Louisiana, I think it was the United Conference of Catholic Bishops, all sued the EEOC. They weren't having it. They said, bishops were like, this is my religion. We don't want to accommodate. We shouldn't be forced to do that. State of Louisiana was like, no, states' rights, all the things. And so if we go to the next slide, the Eighth Circuit struck it down. They struck it down. And so that rule no longer applies, similar to the FLSA salary rule that was struck down in Texas. Louisiana, the Eighth Circuit, I think I was talking about, struck this down. And so in short, the holdings were that the EEOC exceeded its authority to implement the PWFA. It was unlawfully expropriated Congress's authority and encroached upon the sovereignty of the states. So we've come full circle back from 24 at Loper Bright, where we're talking about we're getting rid of Chevron deference. We're not deferring to the agency on their final rules or anything. We're going to let independent courts and states decide things. And 2 years later, we're here at this at state of Louisiana, and the PWFA final rule regarding accommodation of abortion has been struck down because now the court had to got a chance to use independent judgment, and they didn't have to defer to the EEOC's final rule. Now, but for Loper Bright, is this case decided differently? Probably. It's probably decided differently. I'm not saying that the holdings wouldn't be the same, but I'm sure if the split's different. I'm sure the dicta and the conversation, the reasonings that the court uses is different as well. And so that's why it was important for us to travel the long road to see where we have been and how this change started happening before the election, and then really got pushing come January 25, and it's going to continue. It's going to continue. So obviously, if that's something we need to help assist anyone on, please give us a call. Lastly, this is going to be real quick. South Carolina legislation, the biggest thing is just know this bill, the anti-DEI bill, just like the executive order that was issued earlier this year, it's been talked about. It's coming possibly at some point. Didn't get passed this past session, but please note, just like death and taxes, this will be talked about next time they go over into across the street. It's coming. So just be mindful. That's why start your audits now, looking at things and adjust. So this completes the presentation. Obviously, everyone can get a copy of it. If you have any questions, we're happy to answer those now. If you've got questions you want to ask us offline, please email Katie or me. But as always, we're happy that you decided to spend your lunch hour with us. You could have been anywhere in the world, but you chose to get with me and Katie, and we appreciate that. One day we're going to be standing up for you one day, and maybe have some more interactive things that we can figure it out. But thank you. If there are no questions, are there, Katie, questions? You see any?
I haven't seen any other come through. Nope.
All right, well, if no questions, please hit us offline if you think of something. But thank y'all so much for coming. We really appreciate y'all coming to these things. We put a lot of work into them, and it's always good to see how many people sign up. So thank y'all again, and if we can ever help y'all, please give us a call, shoot us an email.
Thanks, everyone.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.